their goal of taking out Voting Rights Section 2, or 4 and 5, the preclearance provisions. And as you noted, they said, of course, you still have this individual enforcement option available. And then the project, of course, began to take out the individual enforcement option. And that's what we see coming to a head here in Callais. And this is, I think, a pattern that we've seen time and again across various issues with the Roberts Court. Of course, no issue is perhaps more damaging to our democratic system, combined, I think, with these voting rights cases, than the issue of money in politics. And in the 20th century, you have this incredible progress, bipartisan progress, importantly, near unanimous Congresses passing bills to limit unlimited money in politics, most importantly, the Bipartisan Campaign Reform Act, the McCain-Feingold bill that was the subject of Citizens United. And the Supreme Court told us the same thing in striking down that bill that was designed to keep billionaires from owning our country. They told us, well, at least we'll have disclosure and we'll be able to know who's doing it, and so there won't be corruption. But then, of course, the system of dark money in politics emerges, and the Supreme Court has no problem with that. So we have no disclosure, and that creates systems like we saw last fall with Elon Musk effectively purchasing the presidency for Donald Trump, and the incredible corruption that ensues from that. And you can take that same dynamic in pretty much every issue area under the sun, and you can see the advance of these agendas. The handouts, the unbelievable handouts to the billionaires that are responsible for these justices having their jobs in the first place, through the decimation of our public agencies that keep our air clean, that keep our water safe to drink. The billionaires don't like that stuff. Fossil fuel billionaires don't like that stuff, and they realized they couldn't pass it through the legislature, and so they bought the Supreme Court to give them that. And that's the agenda that they've produced. And this is the world that they have produced, this miserable world where the hopes and dreams that we have long had for ourselves and for our children just seem out of reach to too many people, because we have been told by this Supreme Court majority that all of the things that we work so hard to achieve, that we sacrifice for, that your community in particular, the black community, shed blood to achieve, that those things are foreclosed by the Constitution, by these justices' unilateral, exclusive determination of constitutional meaning. And so we find ourselves in a historic moment. The one that, frankly, that Lincoln and the country found ourselves in during the Civil War. When at the beginning of his first inauguration, Lincoln said, if the answers to the vital questions affecting the whole people are to be irrevocably fixed by the Supreme Court, then the people will have ceased to be their own rulers. And that's what's happened. We have ceased to be our own rulers, and we've all taken it lying down. And so now that we see this court can't stop Trump, it doesn't want to stop Trump, and it doesn't have the power to do so, we need to recognize that it doesn't have the power to stop us either. If we leverage our collective power, if we lock arms across our issues, recognize that the obstacle to our progress, the source of all of our stolen progress, is the same corrupt cabal of justices that have been working in lockstep to advance this political project, and that the source to the restoration of all of our stolen progress is the same, just through collective action and democratic empowerment. We can do this, right? And so, on some level, it doesn't matter, what the Roberts majority does with this Callais case. We know what it will do. They've already told us what they will do. And we've seen the folly of over-reliance on hoping that they will do the right thing or do the least bad thing, right? So the time has come, right? We've seen what this produced. We've seen the devastation it's produced in our communities and the fear that so many of our friends and family are living through right now. And it's time for us to just say no, that we won't accept this, and that we can craft a better way forward. And I look forward to doing that with you two.
Yes,
right.
And we
Alex,
go ahead.
Yeah, and Alex, one of the questions that's out there, because there's some of our listeners that are listening to this case and are listening to this program, and they're like, what is this Callais thing, that they're talking about? This Louisiana case. Can you, sort of run through what the Louisiana versus Callais is all about, and how it is that it's being argued for the second time within a year? It was argued in March, and now we're here in October arguing what appears to be the same issue, only a little broader.
Right, of course. Yeah, it's definitely worth breaking it down, because I think this is actually one of the tricks that the right-wing legal project has used to lock us out of knowledge about what's happening in our lives, is using all of these case names and fancy doctrines. So let's break it down. So, under the Voting Rights Act, voters of color must have an equal opportunity to elect candidates of their choice. And so from that, we have a whole body of case law about, how that right under the Voting Rights Act is to be recognized. And in the context of gerrymandering or redistricting, it means that, communities of color must have adequate representation in the lines that are used to draw our districts. And so one thing that we've seen in recent years are attacks on state efforts to remedy past discrimination as demanded by the Voting Rights Act, as demanded by all that case law, to make sure that communities of color are adequately represented. And the argument that the right-wing lawyers challenging these maps are bringing is that this effectively constitutes anti-white discrimination. And this is an argument that the Republican justices on the Supreme Court clearly are open to. It's an argument that they, in fact, made themselves in the context of affirmative action in higher education when they struck down affirmative action. And in a case not that long ago, it's actually the case around which Barbara and I first met, where Evan Milligan and a class of plaintiffs challenged racist lines, racist gerrymandered lines in Alabama. The Supreme Court, in a somewhat surprising decision, ruled that Alabama's maps were indeed racist and that they would need to redraw them so that blacks in Alabama would have access to a second voting district so that their political choices could be reflected in voting decisions. And, that was, sort of taken as a big win for voting rights plaintiffs because, the Supreme Court didn't do the worst thing. But in that opinion, in a concurrence in that opinion, Brett Kavanaugh effectively told us that, it was only a matter of time before this argument that efforts to remedy past discrimination constituted unconstitutional anti-white discrimination would be taken very seriously at the court and would be used to strike down Voting Rights Section 2. And so when the court heard this case last year for the first time, many feared that they would use it then to strike down Section 2 once and for all, but they didn't do so. And I think the reason they didn't was that they didn't want to further inflame the situation during the middle of an election in a way that I think they thought would harm their power, harm public faith in their neutrality. And so they waited, and they are doing it now. And so now that the argument is back up, it's going to be heard tomorrow morning. And I think we have all indication that the three justices who voted in the Alabama case to strike down Section 2, now joined by John Roberts and Brett Kavanaugh, will be the 5 votes to strike down effectively Section 2 of the Voting Rights Act.
Wow. And, it's accurate, is it not, Alex, that when the case was first argued by, Janae Nelson and the Legal Defense Fund, that, they were arguing what seemed to be just strictly about the constitutionality, I guess, or the violation of the Voting Rights Act Section 2 as it applied to the Louisiana maps that were drawn. But then the court did that unusual thing. I can't recall many instances where the U.S. Supreme Court says, you know what, we need to rehear the arguments and change the question that you're answering a little bit. The question becoming, rather than did Section 2 of the Voting Rights Act, was it violated, we want to hear, did race predominate in drawing the redistricting lines? Now, whether the creation of the second district violated, as you said, the U.S. Constitution. And, is Section 2 really outdated and no longer needed because of the advances that have been made, racially in the country? Help me out. It seems as though they're putting some say their thumb on the scale. I think they're throwing the whole daggone body on the scale.
Yeah, exactly. No, that's right. I mean, and it is atypical for the justices to do things like this, although you see it more often on important political cases where they will manipulate the timing of when they grant a case, where they will change the question presented. Famously, they did this in Citizens United, where they invented an entirely new question that had not been considered at the lower courts. And of course, that's essential for the functioning of a judicial process. You can't review a legal question on appeal that wasn't actually resolved below through the trial and appeal process. And so you can see the way the court's manipulating things. And that's exactly right. When the court had the case last year, they were reviewing a much narrower question about whether Louisiana, in following a judicial order to redraw its maps to create a second black district, whether it was we're acting predominantly based on racial views, and that question is a much smaller and easier to resolve question. The motivation for the Louisiana legislator was fairly straightforward insofar as they had to respond to a judicial order requiring them to redistrict. But now we are here, and you can see in exactly how you've described, Daryl, the justices turning this case into something different and much, much bigger.
In order to once again threaten and eliminate black political power. The other thing that we wanted to make sure we covered with you, because I know people have been saying, what in the world did the court do with this decision in Nome versus Perdomo, Vasquez Perdomo case? And they're saying, that they actually, Justice Sotomayor wrote in her dissent that this case, posed several problematic elements. She says that it allows indiscriminate immigration stops, rubber stamping, racial profiling. Everybody's been, looking at that. And she actually said we should not have to live in a country where the government can seize anyone who looks Latino, speaks Spanish, and appears to work a low-wage job. Rather than stand idly by while our constitutional freedoms are lost, I dissent. Yeah. What did you make out of that case, and what do you see is happening with these powerful dissents that we're reading from, Justice Ketanji Brown Jackson, Sotomayor, and Elena Kagan?
Well, I mean, thank goodness for these justices writing in dissent. This is certainly a moment for vocal dissent, and I think it's also important to acknowledge the bravery and courage of many, many lower court judges who are writing tremendous opinions, speaking out not only about the abuses of the Trump administration, but of their frustrations with the Supreme Court and its guidance. And, it's not only what it has allowed to transpire through its shadow docket rulings, like the one you mentioned in this Nome case, but the lack of guidance that the justices have given to lower courts trying to figure out how to resolve legal challenges to this unprecedented constitutional breakdown. And so, in this case, I think you can see these concerns at a peak. This is a shadow docket order, again, unsigned and unreasoned. In this case, there was a Justice Kavanaugh concurrence explaining why he thought that these flagrantly unconstitutional, racially profiled stops would be valid. People have started referring to these as Kavanaugh stops, which I think is useful because it assigns agency and accountability to the justice that tried to defend this flagrant attack on our Constitution. But at the same time, the opinion is threadbare and gives no guidance for how we should understand this or where it leads us. And so, while the dissents, I think, are vital and essential to pointing this out, I think what we are left with is really unsatisfying, right? Because the administration is allowed to proceed with this, this strategy of arbitrary roundups and racially targeted attacks on our communities. There are no guardrails to stop them. Dissents don't do much to actually stop the situation. And, the harms transpire even as litigation on the merits proceeds in courts below. And so what I think, we're seeing in a case like this and in so many more of the shadow docket cases where the abuses continue even as the litigation transpires, we don't have a constitutional order. We don't have rule of law. And so that leaves us in a really challenging and unprecedented position about how we exercise our rights as citizens.
And I want